Hello everybody, I'm going to be on the road driving down to Ashland County tomorrow to do some filing. So I'm doing my video on Monday this week, and I was just going to talk a little bit about some recent changes that took place in July of 2026 to Ohio Rules of Superintendence. Now this is really, I guess, kind of inside baseball for attorneys, but essentially, like when you had a guardian ad litem involved in a case, and I am a guardian ad litem, the Ohio Rules of Superintendence talked about, your duties as a guardian ad litem and what you had to do during your investigation and when your report was due and who to disclose the report to. And you would always have to put the same bold warning on your orders that said basically, pursuant to Rule 48.06A2 of the Rules of Superintendence, the following notice report is given. This guardian ad litem report shall be provided to the court, unrepresented parties, and legal counsel. Any other disclosure of the report must be approved in advance by the court. Unauthorized disclosure or distribution of the report may be subject to court action, including the penalties for contempt, which include fine and/or incarceration. So that was the old warning, and that led to a lot of confusion and consternation between attorneys and clients, because a lot of attorneys read that and concluded, said, well, I can't share this report with my client without court permission. And so parents who have paid a lot of money to their lawyers and paid a lot of money to guardian ad litems and been told throughout the entire litigation that, pretty much whatever this guardian ad litem report comes back and says, there's a good chance that that's what the court's going to do. So these, clients are waiting very eagerly for, to get this GAL report back, only to be told, well, you can't read it. And then the lawyers would summarize it for them and tell them. I always, in Lake County at least, provided a copy to my clients, because I asked the magistrates, what their position on it was, and they said, well, yeah, you can, share it with your client, because I wanted them to be able to read it. But I usually had them read it in my office with me so I could be sure that they weren't giving it or sharing it with anybody else that they shouldn't have. Now, thankfully, as of July, that controversy is over, because they changed the wording of it. So they changed the wording of the rule. Is now what was Rule 48 is now Rule 8, and it states, effective July 1st, the guardian ad litem has provided this report in accordance with the rules. Well, that part's still basically the same, but what's different is Superintendent Rule 8.06C now says the guardian ad litem shall provide a copy of the report to court, unrepresented, and legal counsel, who shall provide the report to their client. From there, parties are prohibited from reproducing, copying, sharing, or distributing the report, or any part of the report. So what I think the huge, great change there to clarify all this for all of the attorneys who work in this area is, now it is saying you shall provide the report to your client. So that's really going to clarify things. I think that's a great change, because I think, like I said at the beginning of this video, people pay a lot of money for a guardian ad litem, and they've been told how important the guardian ad litem report is going to be in the outcome of their case, only to find out that they can't see it. So anyway, that is a new change to the Ohio Rules of Superintendence. Hope everybody has a great week.